Prime Minister, so the High Court would have examined earlier this week submissions from the various parties regards to the elections petition. You would have made some submissions. Could you give us an update on where the hearing of the petition is at the moment?
Firstly, we must understand what transpired on the last occasion when the elections petition proceedings was heard. You will recall, and your viewers will recall, that on the last occasion, the court heard arguments from myself and Mr. Mendez, senior counsel, appearing for respondent Bharat Jagdeo on the question of service. In particular, the court heard an application filed by Mr. Mayor Robertson, in which Mr. Mayor Robertson attempted to get my application struck out. My application is to strike out the petition on the ground of defective service. Mayor Robertson predicated his objections on two grounds. One, he sought to argue that I did not get permission from the court to file the application, that I got permission from the court only to file submissions. And secondly, he argued that the procedural mode that I employed to strike the petition out is wrong. On the first ground, the Chief Justice said that it is true, and I conceded that it is true, that strictly speaking, I did not receive permission from the court to file any proceedings, but simply to file submissions. But I thought it necessary to file the proceedings because my submissions that I intended to make depended upon certain factual ingredients which I had to put to the court in the form of the application which I did file. But no one suffered any injustice. My application did not prejudice anyone. It did not plead any new material. All it did was to set out some facts, all of which are known to all the parties, and then those facts were used as the platform upon which I made the legal submissions. So the court overruled that part of Mr. Robertson's submission on the ground that it really is without merit and that my application didn't harm anyone. Secondly, the court also overruled the second limb of his submission because I was able to point out to the court that the election rules and regulations set out in the National Assembly Validity of Elections Act are silent on the question of the procedural mode that one is to employ if one wishes to strike out an elections petition on the ground of non-service. The rules currently are silent on that under the National Assembly Validity of Elections Act. And over the years, what lawyers have done, and I'm speaking about 100 years of history, what lawyers have done and what courts have adopted and approved is for lawyers to use the existing High Court rules to supplement that vacuum, which is contained in the electoral rules. So what lawyers did was, if it is an interlocutory application, and an application to strike out is an interlocutory application, you use the mode of procedure that is extant under the current High Court rules. And you use that as the mode to do the striking out. And courts have approved that for over 100 years, as I said. All I did was to look at the High Court rules, currently in force and use the mode used under those rules to do a striking out application and employ that to strike out the petition. Mr. Robertson found that to be very objectionable, and he asked that it be dismissed on that ground. Of course, the court overruled him. And in the course of my presentation, I pointed the court to the fact that Mr. Robertson himself and the lawyers for the other petitions did the identical thing that I did, because they were confronted with situations where the electoral rules did not provide, for example, on how you get leave to issue a petition, which is a condition precedent before the petition can be issued. You have to go to a court and ask the court permission to issue the petition. How did they do that? They used the same current High Court rules in force, using the procedure available there. They got leave to extend time for service. They got leave to effect substituted service by registered post. That the applications that they filed to do that, they used also the High Court rules, current, and that's all I did, using the current High Court rules, because the electoral rules were silent on the matter. So the court dismissed that application of his, and the court should have awarded costs, but it didn't. But it is clear that the lawyers who are appearing in these petitions for the petitioners are in disarray, because one is objecting to exactly what the other did, and they are on the same side. So clearly there is an implosion. There is some degree of confusion within and amongst the ranks of the lawyers. That is reflected again by the fact that we have received a notice from respondent David Granger to say that he is not contesting or opposing the petitions. But the very lawyers, his own lawyers, they named him as respondents. Is it that they did not consult him before they named him as a respondent? Is it that they are confused about what the law says on the issue, and therefore how the procedure should be approached? Is it that they are not speaking to each other, or they're not speaking to their clients? Or is it that they don't understand the law? All these issues arise because of the clear inconsistencies and clash in process and in law in relation to these elections petition. So having named Mr. David Granger a respondent and having sued Mr. David Granger, they now got Basil Williams to file a notice to the court to say David Granger is not opposing the petition. So one is left to ask, well, why name him in the first place? Then the other reason may be, you know that they have served respondent David Granger late. They serve him with the petition outside of the time delimited for the service of the petitions. So, at least one of the petitions, and we have clearly identified that, and we are challenging that petition on that precise ground. Perhaps they think that if they get now Mr. Granger to put in this document to say that he's not opposing the petition, then the argument that the petition was not served properly on Mr. Granger, was served late on Mr. Granger, would be neutralized, because he's not a respondent. He was not a respondent proper in the first place, and he has indicated that he no longer wishes to oppose the petition. Perhaps that's their thinking, because they can't get around the late service, and the late service is fatal. All the case law authorities that we have found existing throughout the Commonwealth over the last 100 years. They say uniformly and consistently that once a petition is not served in the manner provided for by the rules, then that the court has no jurisdiction to hear that petition. Perhaps they think that to circumvent this identified and proven deficiency, they can now get Mr. Granger to file this document to say, I am not opposing. And if that is their thinking, again, they are wrong. Because whether a person is a proper respondent and whether that respondent, having been named, can exercise a right which the law gives him not to oppose are mutually exclusive concepts. You have a right to be a defendant or a respondent, and you are named a respondent. You also have a right, if you wish, not to oppose that petition, having been named a respondent. They are not the same thing. They are mutually exclusive concepts, and they are governed by independent and significantly different legal principles and legal precepts. So if they think that by doing this, our argument in relation to whether David Granger was served or not evaporates, they are completely wrong. In conclusion, what is clear is that they are in confusion. Monday is fixed for continuation of the submissions on the applications to strike out the petition on the ground of non-service. So let us see how we move from there after Monday's hearing. Thank you very much.